all Scott's fault.
Absolutely. Welcome, ladies and gentlemen, to this June 28th, almost July, here in the CL and Connolly Council Chambers, fourth floor of the Cuyahoga County offices here in Cleveland, Ohio. Roll call, please.
And just as a reminder to all who are in attendance, this meeting is being recorded and live streamed on the county's YouTube page. Calling the roll, Mr. Gallagher,
Here.
Ms. Conwell,
Present.
Mr. Tuma,
Here.
Mr. Jones,
Here.
Ms. Simon. Ms. Simon is absent at the moment. There is a quorum.
Public comment.
No, Mr. Chair, no one is signed in.
In your packets, you'll find the minutes of the May 31st committee meeting. If they're in order, I'll accept the motion in a second.
Make the motion.
Second.
Thank you. I have a motion and a second from the president. All in favor?
Aye.
Against? 2022-0173.
Resolution number 2022-0173, approving of revised assigned counsel fee schedule for the Cuyahoga County Court of Common Pleas, General and Juvenile Divisions, and the 8th District Court of Appeals.
All of them. Judge, are you going to command this for everybody?
Hopefully, I'll lead this the correct way. First of all, I want to thank council for allowing us to be here today, specifically Councilman Gallagher, the chair of the Public Safety Committee, for inviting us to speak today on the court's request to increase assigned counsel rates in Cuyahoga County. I also want to thank all the council members for considering an increase in the assigned counsel rates and for the work council staff and all the people who worked on this to be here today. I also just want to take a minute to thank the Cleveland Metropolitan Bar Association, who has representatives here today, the Cuyahoga County Criminal Defense Lawyers Association, who have representatives here today, and the Norman S. Minor Association for supporting this request. Also present today, I know Councilman Gallagher will appreciate this, is Mark Stanton, and Public Defender Colin Sweeney, who have been mentoring and helping us and trying to lead this to get to this point here we're here for. As all of you know, the right to counsel is guaranteed and a fundamental to the United States and Ohio constitutions and to the judicial process. The action that you are considering today guarantees the availability of assigned counsel in Cuyahoga County remains strong, and that the people who come before the court have the best attorneys available to represent them. Assigned counsel in Cuyahoga County are extremely dedicated, and I have to say, humbly, the best attorneys in the state of Ohio. They zealously represent their clients every day in our courts for compensation no longer considered reasonable by today's standards. Your consideration makes clear to assigned counsel that the work they perform is no less valued than the work that they may perform across the state. I also want to take this opportunity to introduce the administrative judges of the Court of Appeals, Judge Sean Gallagher, and the administrative judge for the juvenile court, Judge Tom O'Malley. I want to thank them and their staff for their efforts for joining the General Division on this request to increase assigned counsel rates. And I'm going to ask if it's okay with counsel if they want to come up and make a couple of remarks, if that's okay. Please. Judge Gallagher.
I know brevity is a virtue. Look, there's a lot of great attorneys that are out here representing a lot of what they do every day. I've been in this business for 40 years. I'm going to tell you something. What they do and what they offer the public, especially the poorest of the poor, is really, really critical and important. That, what these people do is really exemplary. And listen, I was on the other side of the coin. I was a prosecutor for my career, but I respect these people. They're great. They do a great public service, a great job for everybody, and I hope you'll consider that. Thank you.
Thanks, Judge.
And then Judge Tom O'Malley from the Juvenile Division.
Thank you for acknowledging me today. The only thing I'd like to say is that When I started on the juvenile bench 15 years ago, our assigned counsel list was 5 or 6 pages long. When I looked at it this morning before I left, it was about a page and a half. And you know, as well as I do in the news, the crimes that are being committed by juveniles are not stealing tennis shoes and not stealing bikes. And what we need at juvenile court are attorneys like Tom Shaughnessy back there to get on our list, because there's murders, there's carjackings, and we're losing them because it's just not cost effective for them to come to juvenile court or even on the assigned counsel list. And that's basically the gist of what's going on at juvenile court. Our assigned counsel list is dwindling, and something has to be done, and I hope you consider this. Thank you.
Thank you, Judge.
I know this is not in my script, but I would ask if I could, a lawyer who has represented indigent defendants for many, many years, and also was our former public defender, Mark Stanton, if he could come up and make just a couple comments.
I was going to ask for Mr. Stanton to come
Yeah,
up.
Mr.
because
Stanton.
It's always a highlight.
Mark, come on up. I figured he'd add some viewership entertainment.
If I could capsulize for you, and thank you for this opportunity to appear at any time before this august body is a distinct and indelible honor for anyone. If I could capsulize just one incident for you. 1978, half the people back here were not even twinkles in their parents' eyes. 1978, I left Columbus as an assistant attorney general and came back to Cuyahoga County to be an assistant county prosecutor. I was assigned to the courtroom of Lloyd Brown, only the second African-American to serve a term on the Ohio Supreme Court. Juries were mesmerized by him. He had a commanding presence. He had a rich and sonorous voice. He commanded the courtroom. I had a trial set in front of him. He had just accepted a plea on a murder case. He walked out, and in that baronial style, he said, "Stanton, I got something to show you." He walked over, he put a fee bill in front of me. This is 1978. Of course, my left leg's going 2,000 RPMs because they think I'm going to trial. He says, "Your case is going to plead, don't worry about it." And he circled in red the figure $2,750. My eyes widened. He said, "You know, you can pay a few utility bills, pay a few portions of rent with that $2,750. I was making $12,700 at the time. That was 22% of what I was making. And after my eyes rejoined the human race, I thought about that. He says, "But I want you to do one thing. Before you leave and go down to your office, I want you to stop by my chambers." So I went back to his chambers. He says, "You realize why your case just pled and while that murder case pled?" And in a flippant, unadvised manner, I said, "It's because the defense attorneys hadn't done their diligence." He says, "I don't really think that's part of it." He says, "But the bottom line is they needed the money." This is 1978. They needed that $2,750 or $750 on the aggravated robbery because they can't sit around. And as he said, he can't sit around for 2.5 weeks in a murder case. He's losing money every place else. He can't sit around for 3 or 4 days on your case because he needs to do something else and generate some money to keep his office going. I would just echo what Judge O'Malley said. After 5 months of being in juvenile court, I have begged, abject begging of leading defense attorneys in this town to come out to juvenile court. You're desperately needed. And they said, they understand the desperation, but they also understand that being paid at rates of 1978. You know what you get paid for a murder in juvenile court today? The same amount, $2,750, that unfortunate fellow who needed the money pled a case 44 years ago in common pleas court. The small coterie of defense attorneys that are in juvenile court do their best. They're well-intentioned. But well-intentioned is not synonymous with diligent representation. Well-intentioned is admirable and genuine, but it's not synonymous with ensuring effective assistance of counsel to these kids. You want to wipe out recidivism? That's the place to do it. And the commitment of the magistrates and the judges in juvenile court is unbridled. It's only equaled or exceeded occasionally by a probation department which utilizes every resource available to ensure that no child is turned away. They refuse in that probation department to concede that any child is lost. The attorneys need the same motivation. They cannot, most of those fellas and gals don't even have offices because they can't afford it. So it's the appropriate thing. I've never been in front of this council where you didn't look at everything completely. You've always reached the right decision in the few instances I've been here, and I have every confidence that you'll do so in this regard. But I'm telling you, or suggesting to you strongly, that the future to reducing recidivism at its inception is to give the money to the attorneys that need it, because the attorneys cannot take money out of their own pocket, which they have to do consistently, to go out and pay an investigator, and they're paying an investigator to the extent that their entire fee is wiped out. You just can't have that situation and ensure representation for defendants, especially juveniles. So I thank you again for this opportunity. I have every confidence that you'll do the right thing.
Thank you, Mr. Stanton, and good seeing you.
And I'd be in trouble if I didn't introduce Tom Shaughnessy from the CCDLA. Mr. Shaughnessy?
Good afternoon.
Thank you for having us here on behalf of the CCDLA. We have our president, Tim Huber, our president-elect, Craig Schmatzer. I would just echo the things that have been said before. Our organization has been working with indigent criminal defendants for the last 30 or 40 years. I think you're all aware of the fee at this time. Mr. Stanton just said that murders are $2,750 in 1977. Today, it's $4,000. So since 1977 till today, it's gone up $1,300. I know you have all the legislation in front of you. I would just echo the sentiments of everybody else and ask you to please take a really good look at this. Thank you.
Thank you.
With that being said, I'm going to look. Did I miss anyone else that's in the audience that I missed? All right. I think I got everyone. I really just want to push the fact that this wouldn't be possible. Our leadership and our court administration, all the administrators from juvenile court, from the Court of Appeals, and from our court, Greg Popovich. And he's here, and our finance person from the court is here, Colleen Brown. If you have any questions regarding our request, our staff from the representative courts are here to answer anything you may have. So I want to thank you for the opportunity to be here and present this to this council. Thank you.
Thank you, Judge. I think you hit the right committee, because we have Mr. Tuma and Ms. Simon, who are certainly helpful in this avenue, and myself, who was with the court. And I remember a time when just taking an appeal was $250 in 1983. I remember specifically David Doughton, who just always was doing favors for the judges to take the case and then having to have a pocket full of quarters to do copying until we found out and started copying for him, realizing that that came out of his pocket. So the injustices of those that were serving the court really weren't very well recognized back then. But we talked before we started, and Ms. Simon, maybe you can help me. What was it? We upped the fee not long. Well, it was quite a while ago, but I don't recall when. Do you recall when?
No, but we just recently increased GAL fees within the last 12 months, I believe, and the signed counsel rate has been longer.
Yeah, I know these two have the answers. So, Greg, do you know when the last time?
Give a little bit of history behind it, Councilman. So the last time rates were increased in Cuyahoga County for the general division, there was a discussion in 2013. This body passed the increased rates in 2014. For juvenile court, the last time they were increased was in 2008. Again, the only exception would be the guardian ad litem fees that I believe was last year. So.
I'm just wondering why it took us so long to get here.
Unfortunately, I hate to blame COVID, but COVID was a little bit of a hiccup on that, and just getting it together. And so it's a collaborate group. Mr. Stanton and Mr. Shaughnessy and the CCDLA have all been working hard to get it before this body. So thank you.
Is there anything that because costs always go up. And I'm just wondering if lacking in the legislation isn't an escalator. Meaning, I mean, we get cost of living when you retire. We don't get cost of living here. We get 1% or whatever it is. But the cost of living is calculated into your retirement usually, and sometimes into the contracts that we have with our union and non-union employees. If we were to pass this as is, without an escalator, you'd be coming back in 2, 3, 4, or 5 years. Is it proper to have, are we able to do that, number one? And would that be a request, number two?
Yeah, I would, it's always be good to do that so we don't have to keep coming back. But I'd let Greg talk about
I
that.
think one of the advantages of this piece of legislation, Councilman, is that it actually is automatic. So when there's increases made by the State Public Defender's Office, the rates for assigned counsel will go up accordingly. To be able to, I know there was a consideration regarding the county's budget. If they did, the reimbursement rate went down, it would go down. But as soon as they were increased again, they would go back up again. It would be all automatic in the future. So hopefully, the courts would not have to come back. You would not have to entertain this piece of legislation again in the future. That would be the hope.
Yeah, it just seems, well, I mean, that's your call. It just seems to me it would be a reasonable request, but, you know, if it hasn't been that well thought through, maybe it's not the ideal time to do that right now, but maybe in the future, if, yes, sir.
Councilman Gallagher, I think your point is very well taken, and there is the prospect that this legislation could be tied to the rates of increase that are given to the Ohio Public Defender, and that way, that would be an equitable way of doing it and creating somewhat of an escalator clause that would be there. You could check that the Ohio Public Defender Commission would probably, I'm going to guess that might be on their website or somewhere, somebody would have access to that, but that might be a good way to do it so that we can ensure that if that funding goes up for the Ohio Public Defender, it'll also go up for the local attorneys. Thank you.
Hi, Judge.
My
Mr. Chair.
staff is telling me that
It's
already-
there, Mr. Chair. Thank you. It was good to see you, Judge, judges, everybody. No, it's in here in Section 3. It states that in January and July of each year, starting next year, that there'll be a meeting with the fiscal office to advise of the current rates of reimbursement, and the rates will be adjusted according to that scale. So it is an automatic, and when it drops, it will there's a floor that it will not drop below. So we're never going to go way down. It's going to drop, I think, from where we are today, but it will go up and down according to those rates, and review twice a year.
Great, I missed that. So thank you. That's why we have attorneys up here, so problem solved. Any other questions for the judges?
I just want to say thank you for your consideration, and I know from talking to all the lawyers, they are cheering on this legislation and hoping all of you will pass it as quickly as possible. So thank you.
And I thank Ms. Simon and Mr. Tuma for initiating and sponsoring the legislation initially. Not hearing any further questions. Yes, ma'am?
Mr. Chair, if I can, I used to, in my other life, serve as both GAL and juvenile court. I was assigned counsel doing criminal defense work and was, a part of this, people serving because they care about justice and they moving and working for passion, but not for money. And it's gone way beyond the place where we can have a fair justice system when we can't keep people who are committed to criminal defense because of these rates, and in the GALs that are, can't keep it up with all of the work they have. And so I appreciate this, and everybody else does who's doing this work in both courts, all courts. So, and thanks everybody for getting together, all three of you branches of courts to assist us in getting this done. Thank you.
Thank you. Again, hearing nothing further, and I want to thank Mr. Stanton once again for gracing us with his presence. If the committee is comfortable, I'll accept a motion for Resolution 2022-0173 to the full council Under suspension of the rules.
So moved.
Second?
I have a motion and a second. Any discussion? All in favor?
Aye.
Aye.
Against? Thank you. Thank you very much. 2022-0189.
Resolution number 2022-0189, authorizing a revenue-generating agreement with City of Cleveland, Cleveland Municipal Court in the amount not to exceed $2,349,218 for legal services for indigent persons.
And who do we have speaking?
Good afternoon, Chairman and Council. Colin Sweeney on behalf of the Cuyahoga County Public Defender's Office. Just to briefly explain the contract, I'm sure you're all familiar with this. We've had a contract with the City of Cleveland to perform representation in municipal cases since 2004. Before that, it was the Legal Aid Society did it. We handle all the cases in Cleveland Municipal Court unless we're conflicted. So that's in 12 different courts, municipal courts plus the housing courts, criminal court, and then there are many specialty dockets that we handle, including the Village of Bracknell, animal abuse and neglect. We handle tens of thousands, over 14,000 cases a year annually. And this contract, which is substantially, the language of the contract is basically identical to what the one was that was adopted or entered into at the last time. The only difference is there's a 5% increase essentially in the dollar amount. But it doesn't impact the county in terms of cost. It's entirely paid by the City of Cleveland. They get the reimbursement that we were just talking about in the context of signed council rates minus a 3% administrative fee that goes to the county. So they get, it's actually a small, not large, but revenue generating contract. And I think that's about it. This contract calls for a year. It's late, and we can speak to why it's so late, but it's not due to lack of diligence to try to get it through. The Cleveland budgetary process starts late, starts in this year. So we're already operating in 2022. This contract allows for a one-year renewal for 2023 as well to make it a little smoother for next year. So if there are any questions, I'd be happy to address them.
Questions?
Mr. Chair?
Yes, ma'am?
A little off topic with the criminal, the defender of animal abuse defendants. So are you aware and incorporating that abuse registry when handling these cases that we put in place at the county?
Yeah, I mean, the APL, so that's who prosecutes those cases, and they're very aware. So we don't usually argue for it because we're defending the individuals, but the courts are aware, as is the APL.
Yeah, that was my question,
Yeah.
just as long as it's in the,
Yeah, it's in
the discussion of
people.
any plea and,
Yes.
okay, thank you.
Thank you. Anything further? Okay, hearing none. Because of the timeline, we'll move this forward. If I could have a motion for Resolution 2022-0189 to the full council under suspension of rule.
So moved.
Second?
Motion and a second. Any discussion? All in favor?
Aye.
Aye. Against? Thank you.
Thank you, council.
Any miscellaneous business? We're adjourned.